Welcome, everyone. Thank you for joining us for today's webinar, Reduce the Risks of Drug Use in the Workplace. My name is David Galbraith. I'm the Assistant Vice President of Risk Management, Technical Lead at Amerisure Insurance, and I'll be your moderator this afternoon. Before we begin, I'd like to clarify that this webinar is for general information only and is not intended to provide and should not be relied upon for legal advice in any particular circumstance or fact situation. You are advised to consult with an attorney to address any particular circumstance or fact situation. As many of you know, Amerisure is one of the nation's leading providers of commercial insurance. We specialize in managing risk for businesses in construction, manufacturing, and healthcare. We are licensed to do business in all 50 states and have been in business for over 100 years. There are over 750 Amerisure employees with our headquarters located in Farmington Hills, Michigan, and 12 strategically located core service centers around the country. Just a little housekeeping before we get started. If you have any questions during the presentation, please type them into the question box in your GoToWebinar control panel. I'll bring them up during the presentation, and we will also have time for questions at the end. Due to the number of attendees and to avoid background interference, all attendees are muted and will remain muted for the duration of the webinar. Our presenters today are Ryan Anderson and Kathleen Babylon. Ryan is based in our Richmond Core Service Center and has been a part of the Amerisure Risk Management team since 2015. He graduated from Virginia Military Institute with a bachelor's in economics and business and received his MBA from Old Dominion University. Kathleen has been a part of the Amerisure team since 2005 and is currently based in our Phoenix Core Service Center. Kathleen received her BA from Troy University and started her career at Sandia National Laboratories. Both Ryan and Kathleen have a wealth of knowledge to share. So without further ado, I will turn the time over to our experts.
Thank you, Dave. We appreciate the introduction. It's great to be speaking with all of you today. We have a lot of information to cover, so let's go ahead and get started. Today, we will be discussing strategies and tips on how to reduce the risks of drug use in the workplace. We will walk through statistics about current drug use in the United States workplace, the different options available to your company for drug testing methods, the extra precautions you should take with safety-sensitive positions, workers' compensation injuries, and post-accident drug testing. So now we have our objectives. Let's go ahead and get started. Generally, we're not going to be reading slides to you, but I do need to read the following verbatim. Every state has specific requirements. It is important to know the laws related to circumstances in which your company can drug test an employee and the legal recourse your company can take when a drug test is positive. We will not be discussing any rules related to unions, and this webinar is not intended to be legal guidance. Amerisure Risk Management consultants cannot provide specific legal advice, only suggestions. So we're going to be covering a lot of data in this time, and please note that we will be happy to provide this presentation to you should you want to share this data with members of your company, or if you just want to go back and review the data in a specific slide. So let's look at some facts about drug use in the United States. In 2017, more than 72,000 Americans died from drug overdoses. This includes not only illegal drugs, but prescription drugs as well. Abuse of illicit drugs costs more than $193 billion annually in costs related to crime, lost work productivity, and healthcare. Prescription drug abuse, specifically opioid abuse, is a growing epidemic in the United States. Since 1999, opioid prescriptions have nearly quadrupled. What's even more alarming is the addictive nature of these drugs and the impact they have on any given user. 8 to 12% of opioid users develop an opioid use disorder, and as we all know, addiction does not discriminate. When we consider that the United States citizens consume approximately 80% of the world's prescription opioid drugs, it's clear that this problem is real and it's close to home. So now we've touched on drug abuse in the United States as a whole. Let's go ahead and narrow our focus on the United States workplace, which is the focus of this webinar. You may be surprised to find out that approximately 70% of Americans who use illegal drugs are employed, costing employers an estimated $81 billion annually. Workers who report having 3 or more jobs in the previous 5 years are about twice as likely to be users of illegal drugs. 10 to 20% of Americans who are fatally injured at work have a positive result when they're tested for drugs or alcohol. So this chart outlines drug abuse in Amerisure's 3 target markets. The National Survey on Drug Use and Health gathers information about substance use and dependence or abuse. As you can see, the construction industry has the highest percentage of drug use and abuse out of our 3 target markets, with manufacturing next and then healthcare last. When workers are under the influence of drugs, the environment becomes dangerous, not just for the employee, but for their coworkers around them, as well as the general public. Now think about all of those who are touched by the construction, manufacturing, and healthcare industries. Whether the employee is caring for a patient, manufacturing a product, or constructing a home or a roadway, the lives of others are dependent on them being fully coherent on the job. Let's go ahead and look at drug testing results in the workplace. This data is from Quest Diagnostics. In 2016, testing data shows the highest number of positive drug tests in the workplace in 12 years. If you look at the years between 2013 and 2016, there was a 75% increase in positive drug tests for methamphetamine. There was an almost 75% increase for marijuana. Between 2015 and 2016, there was a 12% increase in positive drug tests for cocaine and almost 8% increase in positive drug tests for cocaine in federally mandated safety-sensitive positions. But we're going to go ahead and focus right now on stats related to marijuana use. Right now, there's a lot of questions about medical marijuana, especially in the states that have allowed legal use. There is one note. The ADA, or the American with Disabilities Administration, does not require employers to allow marijuana use as a reasonable accommodation for someone with a disability, even if that person is a registered marijuana user. The ADA is a federal administration, and marijuana at this time is not federally recognized as legal. Medical marijuana. Employers who have federal contracts or federal funding are not necessarily required to accommodate employees with a medical marijuana prescription. Many states will allow termination or discipline for marijuana use or intoxication. However, there is a precedent that dictates an employee cannot be discriminated against on the basis of just having a medical marijuana card. Individuals who use medical marijuana off-site, off-duty, may show positive tests. However, that does not necessarily mean they're under the influence or actually impaired. When you're looking at legalized marijuana, some states will require proof of impairment when there is legalized marijuana use. And again, a positive test does not always mean impairment. Some states allow employers to discharge employees for positive marijuana tests, even though the use of marijuana is legal in the state since it's illegal under federal law. Employers should keep in mind a policy stating employees may not report to work under the influence of marijuana may allow for accepting an employee that uses marijuana either medicinally or recreationally but still has to come to work clear-headed. Before moving on, it must be reiterated, this is not intended to be legal advice. You will have to check with your state regarding employment issues and any legalized use of marijuana. So let's go ahead and discuss a drug-free workplace policy. There are several versions of a drug-free workplace. There's a company policy, there's the insurance company definition in order to qualify for a premium credit, and then there's the state definition, which can often dictate what can qualify for premium credit. First, we'll talk about state definitions. Certain states define what is considered a drug-free workplace with very specific requirements, and some states have more open definitions. In states that recognize a drug-free workplace, the company is often eligible for a credit on their workers' compensation policy premium. In some states with the premium discount, a company must actually be certified by the state to qualify. Secondly, when you're looking at your insurance carrier, the insurance carrier may define what is considered a drug-free workplace. A company will have to meet those expectations to qualify for that premium discount. And those expectations, again, depend on the state. And finally, a company drug-free workplace. That policy defines the company's expectations. It may be consistent with or independent of a state's insurance or an insurance provider's definition. The company may or may not qualify for a premium discount. This is dependent on the company's location. Many companies cannot bid on certain jobs or work for certain customers without a drug-free workplace policy. We're going to look a little more into company policies in a little while, but let's move on to safety-sensitive positions. A safety-sensitive position is a job where the employee holding this position has the responsibility for their own safety or other people's safety. Employers must consider the following regarding safety-sensitive positions. First, your company policy should indicate which positions are considered safety-sensitive. Second, the policy should clearly define expectations of the safety-sensitive positions, including any prohibitions such as legal use of narcotics. Next, companies must make sure that they are in compliance with local and state laws regarding prescribed narcotics and safety-sensitive positions. And lastly, in some states, an employer must make reasonable accommodations for employees who are in safety-sensitive positions and have been prescribed a legal narcotic. This is a general overview of safety-sensitive positions. Let's go ahead and take a look at a few examples of the actual job titles. This is not a complete list, and it can be state-specific. Some examples of safety-sensitive positions could be emergency responders, construction workers, drivers, and those drivers could be CDL drivers or just employees who drive for work purposes, equipment operators, pharmaceutical representatives or pharmaceutical employees, medical professionals, teachers, maintenance workers. Any of these may be considered a safety-sensitive position. Earlier, we talked about company drug testing policies, so let's take a little deeper look into that topic. There are three things that are imperative when implementing a drug testing policy. Firstly, the policy should be in writing and discussed with all employees. This policy should be consistently enforced, and it should be reviewed with employees at the time of hire. What else could you have in a company drug testing policy? We're not going to spend time on every line of this, but it is a general overview of what should be in a policy. Please keep in mind your state or county may have more restrictive conditions for a drug-free policy. So your policy may contain a statement of the employer's policy respecting drug and alcohol use by employees, description of those employees or prospective employees who are subject to testing, the circumstances under which a testing may be required, the substances to which a testing may actually be required, a description of the testing methods and collection procedures to be used, consequences of a refusal to participate in the testing, any adverse action that could be taken based on the testing procedure or results, the right of an employee to obtain the written test results, the right of an employee to have an explanation in a confidential setting of a positive test result, a statement of the employer's policy regarding the confidentiality of the test, a requirement for employees in a safety-sensitive position to report the use of prescription and non-prescription drug use that may cause drowsiness, reduce reaction times, alter behaviors, or others that may impact their ability to safely perform their job. This policy should be restricted to safety-sensitive positions because of HIPAA concerns. But as previously mentioned in the presentation, most states will require employers to try to make a reasonable accommodation for the prescription drug use before suspending an employee from work. Moving on, we're going to talk about testing circumstances. We've discussed a drug testing policy. We want to actually talk about the circumstances in which testing may actually occur. There are generally 4 circumstances when drug testing may be required in the workplace. The first is in the case of a new hire employee. This must be done post-employment offer, and it must be done consistently for all new hires. A statement should be provided to the prospective employee regarding the company's response to a positive test. Secondly, if there's a reasonable suspicion, we recommend that there be a paper trail which leads to this with cause or with suspicion testing. It is important to train employers, specifically managers and supervisors, when this particular type of test should be implemented and have routine refresher training. Please note that this test may not be based on an anonymous tip. Post-incident testing, which should be completed as soon as possible after an incident. Be sure to understand your state or OSHA requirements. And we will be discussing the possible OSHA requirements and later on in this webinar. Lastly would be random testing, and this can be state or industry specific. The system utilized to randomly pick the employees being tested should be formalized and an unbiased system. If the employee count does not allow for a truly random testing, employees may be placed in a testing pool operated by a third party. Please be sure to check your state laws before implementing any kind of random testing at your company. Remember, if an employer institutes a policy of drug testing or alcohol impairment testing, all compensated employees, including officers, directors, and supervisors, should be uniformly included in the testing policy. So once a test has been completed, there needs to be a plan for dealing with a positive test result. So we're going to talk about potential consequences of a positive test. First and foremost, all consequences or responses to any positive drug test must be consistent from employee to employee. The following is just a list of possible responses an employer may choose in the event an employee drug test returns with a positive result. There could be an employee may enroll in an employer-provided or approved rehabilitation or treatment program. This may or may not be covered by the employer's healthcare policy. Another consequence could be suspension of the employee with or without pay for a designated period of time. The employee could be terminated. And if a positive test is returned on a new hire drug test, the employer reserves the right to refuse to hire that prospective employee. So we've discussed a lot of data so far. I'm happy to turn this over to my colleague, Ryan Anderson, who's going to talk about the drug testing process. So Ryan, go ahead and take it away.
I appreciate it, Kathleen. Kathleen's done a great job of outlining why companies need to perform drug testing, the components of a company's drug testing policy. I'd like to shift gears and provide some takeaways that can help you use that policy to be more effective at improving your workplace safety. The first 3 takeaways I'll provide are related to the drug testing process. This slide outlines the drug testing process, and we won't go through each step, but I do want to touch on some aspects of the process in the event of a positive test or when drugs are detected in an employee system. If a sample tests positive in the lab, the sample is tested again for confirmation. If the second test returns a positive result, the results are sent to a medical review officer, otherwise known as an MRO, which is a physician with additional specialized training. The MRO then interviews the employee and his or her doctor and interprets the test results to see if there is a legitimate reason for the positive result. If a legitimate reason cannot be found, the MRO then informs the employer of the positive test result. However, if the MRO finds a viable reason for the positive result, most MROs will provide a negative result to the employer despite drugs being detected in the employee's system. An example of a viable reason that would be that an employee tested positive for painkillers, but the employee had a valid, verified prescription and the concentrations matched the prescribed dosage. While most MROs would report back a negative test, some will report negative with safety concerns if they are aware that the employee works in a safety-sensitive position. So, this slide highlights 3 takeaways you may need to do to improve your drug testing process. First, use an MRO. While many states require an MRO to interpret the results, others require an MRO for unemployment denials and worker compensation denials. Regardless, utilizing an MRO is a very good idea because it minimizes your company's risk. They interpret the data and you do not have to make certain judgment calls regarding positive results. Second, when selecting a drug testing vendor, it is important to ask how the MRO will report legitimate positives. If you do not know how your MRO reports the results, you may still have uncontrolled hazards in your workplace if employees are under the influence of drugs but passing your drug tests because the drugs are prescribed. The third takeaway is establish a self-reporting policy. The fact that the MRO may report a negative result even when the employee is under the influence of a controlled substance highlights the importance of your company having a formal policy requiring employees in safety-sensitive positions to report the use of prescription medications that may affect their ability to do their job safely. That way, even if an MRO doesn't notify you of the safety-sensitive employee's prescription, you should still find out about it and be able to respond appropriately. Once you have chosen a lab with an MRO, you will need to select a drug test panel. However, there is not an industry standard defining what types of drugs are tested for in each panel. This slide on the screen shows what drugs are typically in each panel, but it varies by lab. Therefore, it is important to ask what is included in each test when selecting a lab. Also remember, for DOT-regulated CDL drivers, you do not have the choice in what drug testing panel is used. The DOT-regulated drug test is a urine 5-panel with expanded opiates. However, the DOT does allow employers to administer a second, separate drug test using the employer's desired panel if they want to test their CDL drivers for more substances than what is included in the DOT 5-panel. When you look at these panel options, it can feel overwhelming about which panel your company needs. However, you probably have a good idea which drugs are most often abused by your workforce. This will vary based upon the age of your workforce, the region of the country, and other demographics, but make sure you select a panel that addresses all your concerns. With the current opioid epidemic, many employers are concerned about opioid use in the workplace. So many employers select the 5-panel drug test because they see it includes opiates and they begin testing employees. To their dismay, no one tests positive for opioid use. This does not mean that there is not opioid use in their workplace, however. The 5-panel test for opiates is testing for pure opioid, so it will detect heroin, morphine, or other drugs with a heroin or morphine base. It is not going to detect synthetic opiates, however, which include fentanyl and methadone, and in certain cases, it's not going to detect semi-synthetic opiates such as oxycodone or hydrocodone. For an employer to comprehensively test for opioid abuse in their workplace, they need to be sure to select a drug test which includes expanded opiates. Looking at the slide on the screen, expanded opiates typically doesn't show up until the 12 panel. Be sure to ask your vendor about options. Sometimes you can do a custom test such as a 9-panel plus expanded opiates. Once you've selected a lab who has an MRO and you've selected a panel, you'll need to start selecting the best testing method. When selecting a testing method for your company, the most common items you'll want to consider are whether the test is easy to beat or can someone pass the test even though they are using drugs, the intrusiveness of the test, the cost of the test, and the lag in detection. The lag in detection is the amount of time it takes after drug use for it to be detected by the test. This varies upon the amount of use, the frequency of use, metabolic rate, body mass, age, overall health, drug tolerance, and other factors. So let's start by discussing urine testing. This form of testing is relatively easy to beat. It has a very high level of intrusion. Depending on the type of drug, the lag in detection is between 1 and 12 hours, and the cost is relatively low. Urine tests are widely used, so they are typically understood by the workforce and is the most likely of all the drug testing methods to withstand legal challenge. The saliva or oral swab tests are difficult to beat and have a low to mild level of intrusion. The lag in detection is low as the window of detection begins as soon as the drug is ingested, and the cost for this test is relatively low. Electronic tests are difficult to beat and are the least intrusive. They test current impairment, so the only lag would be if there's a lag in the drug's effect, and the cost depends heavily on the volume or usage of this test. For those of you who don't know what electronic tests are, they are intended for fitness for duty testing, and they feel like a video game that has a lot of quick responses testing your reaction time. What happens is the employee completes an electronic test when they are sober to develop a personalized baseline. Then they complete the task again before starting a work shift. Then you compare to see if their reaction time and other metrics have been compromised. Therefore, electronic tests are not suitable for testing during hire because you need to ensure the employee was sober when setting a baseline. They are not suitable for post-accident or reasonable suspicion testing or any type of testing that may result in discipline, termination, or other HR action because electronic testing detects the employee's fitness for duty, not impairment of drugs. Factors such as fatigue may cause the employee to fail the test. Electronic testing is widely used in mining and aviation industries. However, they are not widely used in any of Amerisure's target markets. Next on the screen, we have hair tests, which are difficult but possible to beat. The level of intrusiveness is high because 120 strands of hair are cut from the back of the employee's head, and the lag in detection is 1 to 7 days prior to the test, which makes it unsuitable for reasonable suspicion and post-accident drug testing. The cost is high, approximately 3 to 4 times the cost of a urine test, and many labs limit hair tests to a 5-panel. Lastly, our blood tests. These tests are difficult to beat, have a high level of intrusion, low lag in detection, but are costly. Another factor you'll want to consider when choosing a drug testing method is duration of detection. When it comes to duration of detection, the time span varies immensely by the type of drug and the type of test. But you can see here that saliva tests only detect a short period after drug use. We won't go through each drug, but I will touch on some of the most commonly used drugs. THC, which is the principal psychoactive constituent of marijuana, can be detected through a urine test up to 4 weeks after chronic use, but only 18 hours after using a saliva test. To touch on another example, cocaine and opiates can be detected through a urine test up to 5 days after use and only up to 48 hours after use through a saliva test. These detection windows will vary depending upon the amount of use, frequency of use, metabolic rate, body mass, age, overall health, and drug tolerance. So, what is the takeaway from all this information? Take a look at the graph on the screen, which illustrates the windows of detection for blood tests, oral fluid tests, urine tests, and hair tests. Now, a lot of companies simply select urine drug testing because that's what they've always done. However, the takeaway is management teams need to consider the strengths and limitations of each test and select the test that best matches their management philosophy. For example, some employers want to treat marijuana use similar to alcohol use. Their philosophy is they don't care if an employee uses it over the weekend, but the employee better not report to work impaired. Other employers have a different philosophy and see marijuana use as risky behavior, and regardless of when it is used, they want to know about it to determine if the employee participates in risky behavior. So, if a management team only wants to know if the employee is currently under the influence, they need to select a drug test with a short detection window, such as oral fluid test. The exact length of detection will vary depending on how much the employee used and other factors, but an employer could feel more confident an employee is under the influence of marijuana if they tested positive for THC on an oral fluid test, which has a detection window between 8 and 18 hours, versus a urine test, which detects up to a month for chronic THC users. The reverse is also true. If your management philosophy is employees who are use drugs are demonstrating risky behavior, you'd want to select urine or hair tests, which have greater windows of detection. It's important to choose the testing method that matches your management philosophy. When selecting a testing method for your business, consider all the factors outlined in the previous slides. There are different testing options with varying levels of intrusiveness, costs, windows of detection. You can always work with your Amerisure risk management consultant to determine which method is best for you. Next, I want to provide a few takeaways regarding drug use that is related to compensable worker compensation injuries. Following a workplace injury, getting an employee back to work as soon as possible, even if it's on light duty, typically improves worker compensation outcomes drastically. However, after a severe injury, painkillers, which impair judgment, are commonly prescribed. In a study of 25 states, it was found that 88% of Arkansas's worker compensation claims where a pain medication was prescribed involved opioids. The lowest in the study was New Jersey, which had 60% of claims involving the class of drugs. That means we estimate between 60 and 88% of your injured workers who require painkillers will receive opioids. As a result, we have to find a balance between getting an injured employee returned to work quickly and an employee who is taking an opioid-based painkiller, increasing the likelihood of hurting themselves or others. Another concern is highlighted by a different study that compared healing rates of patients prescribed opioids and those who were not. The study found that the time to heal was significantly shorter for those who had never received opioids, and patients receiving higher opioid doses healed at a slower rate comparing those who had lower doses or no opioids. Although the exact cause for this is not agreed upon in the medical community yet, many believe opioids' effects on the dopamine and other chemical levels in the body prevent the body from fully triggering our natural healing process. To further complicate the matter, if an employee is prescribed painkillers or other medication for a compensable injury and becomes addicted, the treatment and rehab is typically compensable. As many of you know, drug rehab can be very expensive, plus this will keep an employee out of work for a longer period of time, significantly increasing both the direct and indirect costs of the employee injury ultimately adversely impacting your work comp experience mod. So, what are the practical steps you can take to prevent another injury and control your work comp costs? First, if an employee had previously failed a drug test or was prescribed an opioid for an injury, you may want to consider fit-for-duty testing prior to returning the employee to work. However, you should establish this process for retesting now before an injury or failed drug test occurs. Fit-for-duty testing will include an additional drug test to improve the employee is clean. However, you may want to also include requirements for rehab prior to fit-for-duty testing, selecting a test that is harder to beat since the employee will know the fit-for-duty test is coming, and some states will allow periodic follow-up testing after returning the employee to work. Second, you should establish a relationship with your medical provider that you send injured employees to. You can provide them with light-duty job descriptions so that they can select a safety-sensitive position or a non-safety-sensitive position when returning employees to work. You can also ask a medical provider how frequently and why they have prescribed opioids outside of the Centers for Disease Control and Prevention's guidelines for opioid prescriptions. Your relationship with the medical provider can also help establish an open line of communication between you, the employee, and the doctor to determine if the medications they are taking will impact their ability to perform the safety-sensitive job duties. Third, keep in mind that you should remind the employee if they are going to be prescribed an opioid painkiller, they have the option to request a prescription-strength, non-steroidal anti-inflammatory drug, commonly known as an NSAID, as an alternate to an opioid. And in many cases, NSAIDs can be just as effective at controlling pain with lower risks of addiction and impairment. Before we get to your question, the last thing we want to do is hopefully clarify some of the recent confusion around post-accident drug testing. Most of the confusion began in December of 2016 when OSHA issued a new rule designed to prevent employers from retaliating against employees for reporting illnesses and injuries. In that rule, OSHA indicated mandatory blanket post-accident drug testing policies could discourage employees from reporting a work-related injury or illness. However, OSHA did not prohibit employers from conducting post-accident drug testing. Instead, OSHA wanted employers to only conduct post-accident drug testing when there is an objectively reasonable basis that some kind of alcohol or drug use could have caused the accident. OSHA clarified that post-accident drug testing should be performed only when drugs or alcohol could have reasonably been a contributing factor to the accident. For example, an employee making a workers' compensation claim due to a repetitive injury like carpal tunnel syndrome should not be drug tested. It is not likely to be found reasonable that the injury was caused by drug impairment on the job. In contrast, however, should a forklift driver injure another worker but sustain no injury to himself, both the injured and uninjured worker who are involved in the incident should submit to post-accident drug testing. It is likely reasonable that drug use could have caused a forklift driver to hit the other employee, and it is also reasonable that the injured party's potential drug use contributed to the accident. While making the judgment call if drugs or alcohol could have contributed to an accident, employers were also encouraged to consider objectively reasonable basis for the drug testing, such as direct observation of drug use or physical symptoms such as slurred speech, extraordinary agitated behavior, lack of coordination, disorientation, significant decline in employees' work performance, or erratic, unusual behaviors. In the 2016 rule, OSHA also clarified that post-accident drug testing is permitted if another law requires blanket post-accident drug testing. For example, employers still must follow the U.S. DOT's post-accident drug testing rules and will not be in violation of OSHA's rule because their motive is to comply with the federal DOT regulations, not to punish the employee. The DOT rule states if a vehicle is towed away or someone leaves in an ambulance, the commercial motor vehicle driver must be tested, regardless of at fault or possible influence of drugs, alcohol. Likewise, certain states have statutes on the book related to workers' compensation. If an employer conducts post-accident drug testing to meet these criteria, their motive would be to comply with workers' compensation statute, not to punish the employee. After OSHA issued their 2016 rule, many employers became fearful of using incentive programs, discipline, and conducting post-accident drug testing, and even some employers abandoned these practices altogether. So, just a few weeks ago on October 11th, 2018, OSHA issued a new memorandum to clarify some of the misconceptions on workplace safety, incentive programs, and post-incident drug testing. OSHA stated many employers conduct post-accident drug testing to promote safety in the workplace. OSHA still does not permit retaliation against injured workers. However, they clarified that if an employer can prove they consistently enforce legitimate work rules, whether or not an injury or illness is reported, it would prove the employer is serious about creating a safety culture, and post-incident drug testing was being used to support that safety culture. We have covered a lot, so in conclusion, I will summarize some of the takeaways that can help you better protect your workplace from drug and alcohol use. Your company should implement a drug-free workplace program, develop a comprehensive policy, train supervisors on reasonable suspicion, train all employees on policies, management expectations, and available resources, select the drug test and panel that best fits your management philosophy and address your largest concerns, establish a relationship with your medical provider, and remind but not require employees that they can request non-opioid-based painkillers. As a reminder, your Amerisure risk management consultant is always available to assist in developing a customized plan to reduce the risks of drug use in the workplace. Thank you for joining us. We hope you found the information informative and valuable. We are now going to be accepting any questions that you may have before wrapping up today's webinar.
Thank you, Ryan and Kathleen. Great job on the presentation. We'll go ahead and take some time for questions now. Just a reminder, please be sure to type your questions into the question box in your control panel, and we'll wait a moment and see if any questions come through. Well, it doesn't look like we have any questions, so I thank everyone for your time and your participation in the webinar, and please watch your inbox for future webinars in 2019. Thank you and have a safe day.